Welcome to this CDPD 2021 session on regulation and trustworthy artificial intelligence. Artificial intelligence is a challenging technology. It's especially challenging from a governance perspective. Obviously, it crosses jurisdictional boundaries. It raises complicated questions of assigning responsibility and accountability, and it's difficult to understand and even agree on what it is. Of course, it has huge potential to boost productivity, increase innovation and scientific development, and to contribute to resolving global challenges. But at the same time, it bears risks for individual rights and society at large. This makes it very hard to develop policies, let alone regulation, that can meaningfully guide how AI is used and developed, but it also makes it incredibly important to have such guidance in place. Many countries and organizations have been working separately and together to address this governance challenge. My name is Audry Plonk. I'm the head of division for digital economy policy at the OECD. And at the OECD, our committee has been working on AI policy issues for many years now, including at the intersection with other related issues such as privacy, data governance, digital security, and consumer protection. As I said, we've been at the forefront of addressing AI and the AI governance challenge. In May of 2019, the OECD adopted the first intergovernmental standard on artificial intelligence, what we call the AI principles. They include 5 principles for responsible stewardship of trustworthy AI systems. These are aimed at all stakeholders involved in the AI lifecycle, including, for example, the developers and designers of AI systems. And 5 recommendations for national policies and international cooperation. These are aimed at governments, what kind of policies they should put in place to promote responsible and trustworthy AI. As a next step, we're looking at implementing practical guidance for the AI principles. To support that effort, early last year, we launched the OECD.ai Policy Observatory. It's an online resource that builds the evidence base for AI policymaking and informs the debate. In parallel, we also established the OECD network of AI experts, what we call One AI, which works on developing classification of AI systems and the practical tools for implementing trustworthy AI and national AI policies. Among other things, OECD.ai is a database of countries' national AI strategies and policies, more than 600 from more than 60 countries. This resource is open to the public. It is a valuable tool for learning from countries experiencing and trying to govern AI. I'm very pleased to be here today with my fellow panelists to explore different approaches to AI governance and specifically to talk about how regulation can promote trustworthy AI, maintain the benefits, and mitigate the risks. We will look at this issue from different perspectives to better understand the roles of different stakeholders, policymakers, regulators, companies, and international organizations in promoting trustworthy AI. And before I introduce our panelists, let me just ask the technicians on the back end to please mute. There's a lot of background noise for those of us on the panel. So I'm joined today by Barbara Cosgrove. Oh, thank you. Today we're joined by Barbara Cosgrove, Vice President and Chief Privacy Officer at Workday. Barbara will tell us about Workday's proposal for Trustworthy by Design framework for AI. We're also joined by Daniel Braun, the Deputy Head of Cabinet for Ms. Vera Jourova, Vice President of the European Commission for Values and Transparency. And he's going to walk us through the European Commission's plans for AI legislation. We also have with us Raphaël Gellert, an assistant professor in ICT and private law at Radboud University, and he will draw useful lessons from GDPR on AI regulation to promote trust. And finally, we are joined by Francesca Fellows, the director in the data privacy and cybersecurity team at Squire, Patton and Boggs, who will bring the practical perspective based on her extensive experience with data protection legislation. Hello, everyone. Welcome.
Hi.
We're going to start the panel with a few questions, one to each panelist. So, Barbara, I wanted to start with you. Workday, which uses machine learning in its applications, proposes a Trustworthy by Design framework to address this issue of trustworthy AI. Can you tell us a bit more about this framework and how it would work?
Sure. Hi, everybody. My name is Barbara Cosgrove, and I'm the Chief Privacy Officer at Workday. To tell a little bit more about why Workday is passionate about this topic, why we care about this topic, and I propose this framework, I think it'd be helpful to give a bit of context on who Workday is. So Workday was founded in 2005 on the premise that bringing HR and financial applications to the cloud could bring innovation back to enterprise software. And so today, our applications on financial management, human resources, planning, spend management, and analytics have been adopted by thousands of organizations globally and across industries. And more than 60% of the Fortune 50 are on Workday. Our services are deployed in more than 175 countries in over 30 languages. We're proud of our presence in Europe, where we have 21 offices across the continent and over 600 European headquartered customers. So based on all of that, we see AI and machine learning technologies as offering enormous opportunity for our enterprise customers to be able to make better decisions and improve their business outcomes. And that's why we embed machine learning throughout our Workday products. For example, machine learning powered accounting anomaly decisions can help a company close its books at quarter end. With Workday's Skills Cloud, machine learning curates content for workers in our Workday Learning, leveraging data on skills, roles, experiences, and interests. And so we take a look back and say, over the last 15 years, if they've been about automating enterprise business processes in the cloud, the next 15 will be about using AI machine learning technologies to fuel predictions and improve business decisions. We incorporate these through our applications, enabling our customers to make better decisions. However, despite the massive potential that we see in machine learning, it's becoming increasingly clear that these technologies face a deficit of public trust. For example, there's concerns we've all heard about around the use of data, about potential bias, the relative complexity of just how these work, and how, as a customer, an enterprise customer, an end user, how you can really understand what they do and which ones to trust. And so at Workday, we recognize that the promise of AI and machine learning can only be met when it's really widely used, and that's only going to occur when it's also trusted. So we see trust and innovation as really being two sides of the same coin. And to get there, we really believe that regulation is a critical tool for being able to build trust in AI. By implementing the right policy framework, we can address these trust concerns while still continuing to enable innovation. And so we're committed to driving this conversation forward. And earlier this month, we released the proposal, Workday released the proposal that Audrey referred to, for Trustworthy by Design regulation in a white paper called Building Trust in AI ML through Principles, Practice, and Policy. And this is really the concept that innovation and trust are not at odds, but rather they're mutually reinforcing. And it lays out a framework that sets out three primary categories. So the first is transparency, where measures include adopting a public-facing policy, requiring principles, and basically being able to provide transparency about the machine learning technologies to deployers as well as to end users. The second is governance. And so making sure that there's measures such as establishing an internal governance framework, conducting impact assessments. And then the third and final is accountability. And that's making sure that there's ongoing lifecycle evaluations of any AI or machine learning systems and making sure that there's responsible deployment and end use. But all of these are crucial issues, and we're really grateful to participate in today's discussion based on our perspective from the enterprise software industry. So with that, I think it gives the context of why we care about this topic and the proposal for the framework, and I'll hand it off to the next panelist.
Thank you, Barbara. That was very helpful. I'd like now to Daniel. Daniel, the European Commission is expected to publish a legislative proposal on AI this spring. What is the process in taking the decision in favor of regulation? And what can we expect when the proposal is published?
Good evening. Can you hear me?
Yes.
Yes. All right. So if I can do a short refresher on our previous
I think we Okay, thanks. So we're gonna come back to Daniel there in a minute, and hopefully, but in the meantime, let's go over to Raphaël. Oh, you're back. Okay,
I'm
so
back.
okay, great. Go ahead, Daniel. I'll turn the floor to you.
And since this happens every 5 to 10 minutes, I should be, successful in finishing my opening remarks. Yeah.
Okay.
No. So what I was saying was that this commission was from the beginning quite digital. And
Okay, so why don't we move on, Raphaël, to you, if you don't mind, and I know you have some slides to share. So, Raphaël, your academic work concerns risk-based approach data protection. What lessons can we draw from that for developing AI policies and regulations? There's lots of discussion about a risk-based approach, and can you talk a little bit about how they might work together?
Yes. Hi, Audrey. Hi, everyone. And first of all, very happy to be here. So indeed, as you just mentioned, my work, at least some of the work that I did is about the risk-based approach. So I am trying to change slides. I don't know if it's working. So can I have the next slide, please? Yes, indeed. So yeah, so this is just a bit of self-promotion just to show you indeed that I did write a book about the risk-based approach into GDPR. And so in the next few minutes that I have, I just want to make three short points on what we can learn from the risk-based approach in the GDPR as far as regulation and trust is concerned. And so I have 3 points. So one is about the regulatory design. The second one is about regulatees, so the subject of regulation. And then a last point on the regulators. So the first point I want to make on the regulatory design brings us back to the time when the GDPR was being adopted. And one of the key debates that took place at the time on the risk-based approach is encapsulated in this document from the Article 29 Working Party. And at the time, the debate was between a so-called harms-based approach and between a sort of compliance-based approach where the point is to calibrate the compliance measures. So as opposed to this harms-based approach where regulators, so data controllers, have much more freedom to implement data protection mandates. And so that was sort of the huge debate with the GDPR at the time. And here I just want to show a bit the difference. So this is the sort of harms-based approach. And you see basically that there's a lot of freedom and a lot of discretion for the data controllers because, as you see, they are totally in charge of determining what the harms and what the benefits are. So this is why this sort of harms-based approach has been qualified as sort of blank check for the data controllers. So lots of discretion and therefore lots of trust to be given to the data controllers. Now, if we look at the way that the risk-based approach has been implemented, so it's a more of a compliance approach. So you see that we calculate the risks on the basis of the FIPS, so the Fair Information Practice Principle. So I named a few here: data minimization, purpose limitation. So the discretion is much more limited because we have these FIPS that are the basis upon which we do our risk management exercises. So less discretion, less trust. So next slide, please. Yes. So now I want to make another remark on the regulatees. And of course, we should keep in mind that the risk-based approach is always based on trust in the regulatees, because the whole point is that we give them more leeway in order to determine how best to implement the regulatory mandates. So they're supposed to know a bit better. And again, the key question is then how much trust and how much discretion we want to give to the regulatees. And I just want to illustrate this with the provision on the DPIAs and Article 35, because I think that here it's a nice example of, well, on the one hand, not so much trust, and on the other hand, maybe a bit too much trust. So if we look, for instance, at Article 35 and the definition of high risk, we see that here there is not so much trust because this is key. Let's say defining who gets to define what a high risk is key to, well, to making it happen, that the obligation will happen. And so we see that basically data controllers need to look at the definition of high risk in Article 35 and in the national list by DPAs. And then, but this is my interpretation, they also need to look at the, in a residual way, at the high risk criteria in the guidance from the Article 29 Working Party. And so we see that here, well, they still have some room for maneuver, but that there's not so much trust because their discretion is quite curbed. Now, if we look at the way that let's say the surveillance or the transparency aspect of the DPIA, here there is much more trust and much more discretion. So, for instance, one of the big criticisms of Article 35 has been that there are no provisions on the publication of the DPIAs, even a short report. Just so we have no clue who does a DPIA, who doesn't, per the GDPR. So that's been heavily criticized, giving way too much trust and discretion to the data controllers. The language also on the review of DPIAs has been watered down. Now we just say that DPIA review should be done where necessary. In previous drafts, so it was clearly every 3 years. And finally, there's also the point of Article 36, so which says that in case the risk mitigation measures still lead to a high risk, then the DPA should be consulted. And here it's entirely up to the data control's discretion to decide whether, in spite of the risk management exercise, the risk is still too high. And so here, this is really a lot of trust that we put in the data controllers. So I think these are really a few useful pointers, especially when we consider a risk-based framework now for AI, and especially if the regulatees are going to have to determine what types of obligations apply. And the last point that I want to make very quickly is also about the regulators. And here, actually, I was thinking what example I could take from the GDPR, but then I decided to take an example from the field of nanotechnology, because let's say GDPR is kind of technology neutral. It applies to all types of data processing. But here we are really in a field where a new technology is being developed. And I thought that it's actually quite useful to go back to nanotechnology, which, let's say, in the year around 2008, 2012, that was the big boom of nano. And there was quite some criticism about the European Commission's strategy to go about it, because at the time, it was clear that there were some risks, some health and safety risks, but there was still a lot of scientific uncertainty in terms of how precisely to define these risks, so under what context, and so on. And what the strategy of the European Commission at the time was, well, they just decided to do more risk assessment. So let's further define the risks. Let's have more transparency. But there were no measures with real teeth. And that was criticized because in practice, this amounted to a de facto rollout of the technology. And so, of course, we didn't know the precise extent of the risks, but we knew that there were some risks for sure. And I find that the parallel with AI is striking, where we see that there's so much pressure all around to sort of develop the technology, push for it, in spite of all the risks. So this is something I think we should really be mindful of. And so these were all my pointers for today. Thank you very much.
Thank you, Raphaël. That was extremely helpful. And it looks like we have Daniel back. So shall we give it a go again, Daniel?
Yeah, well, I probably said something wrong and AI kicked me out of this conference, but I'll try to give a quick run through of how we sort of arrived at this point when we are discussing looming legislation, and hopefully I'll be able to finish it. Yeah, so first, basically, there was a strong series of measures of this commission to boost the competitiveness dimension, so increased investment from Horizon 2020, creating a coordinated plan with member states to help development and use of AI, but I will not delve into that. But already then we had strong conviction that for companies and people to make the most of these opportunities, there also needs to be trust in the systems, and people need to know that their rights and values are respected. So in April 2019, we came with a document building trust in human-centric AI, that defined the key attributes of trustworthy AI. And we launched also a large-scale pilot phase for feedback from stakeholders that many of you will remember and participated in, I'm sure. And now I can go back almost exactly a year ago when we published the white paper on AI, outlining basically ways to implement this European approach. And we proposed to aim to create what we called ecosystems of excellence and trust. So promoting Europe as a place to develop and deploy AI, and at the same time addressing potential problems. And to do that, we floated the idea to create requirements for AI systems that could mean risk to people's safety or fundamental rights, such as privacy that was just commented on, or non-discrimination. And then we launched a public consultation on this white paper, and we received over 1,200 responses from all over the world, by the way. And the results showed a clear need for regulatory action. If I look at my numbers, 42% of respondents see a need for new legislation. 32.5% say that current legislation may have gaps. Only 3% said that the framework is sufficient to contain the risks. And also a vast majority of respondents were very concerned about the possible infringement on fundamental rights and discriminatory outcomes. And by the way, this white paper came in an even broader framing of the general EU digital strategy, where one objective was technology with a purpose, to shape basically technology that serves people and respects EU values. But regulating AI is obviously a very complex matter, so we have to ensure that companies can innovate. We also have some very relevant rules, as the speaker before me said, for example, on data protection. At the same time, there are clear gaps, there's clear demand, there's also potential risk of fragmentation of the rules. So yeah, so what can you expect? Of course, only good things from us. Discussions are really still ongoing internally, but some principles of the proposal that will come still this spring that you can expect. First, a regulatory approach that is proportionate, not too prescriptive, that does not hamper innovation, and that is based on risk associated with applications of the technology. And any regulatory framework should be flexible enough to be able to adapt to evolutions of technology or the use, which is especially, I think, relevant for AI, and to different levels of risk and human interests at stake in these use cases. So this is why the framework would follow, and you heard that in previous sessions from my colleagues from the Commission, a risk-based approach with mandatory requirements imposed on high-risk AI systems of particular concern. These requirements could include things that you very well know and that Barbara also alluded to, like high-quality training data that respect EU rules, record keeping of documentation regarding data, algorithms, the training, information on performance, robustness, requirements on accuracy, and human oversight, of course. Now, that's requirements. As for compliance, this could be verified through ex-ante conformity assessments before these high-risk systems are deployed, in addition to the market surveillance and ex-post risk control that already exists. But still, this is very much discussed internally, the balance between ex-ante and ex-post and whether it's sufficient. Coming back maybe to conclude to the excellence part, we will also prioritize investments through the next budget that was recently approved on EU level, and through also public-private partnerships. And finally, I shouldn't forget that we will work, of course, towards a stronger international cooperation based on EU work, but also successful G7, G20 initiatives, and naturally the great work of the OECD, in which the Commission has been actively involved. So that's it from me for a start. Thank you.
Thank you so much. That gives us a lot to talk about and think about throughout the panel. And before I look for questions, I want to go to Francesca. Welcome, Francesca. We're glad you're here. And I was hoping that you could talk to us a bit about the practitioner's point of view and what we can learn from the experiences with data protection legislation that could be useful as we think about AI policy and regulation.
Thank you very much. So yes, I mean, there have been some very useful parallels drawn here, of course, between data privacy regulation and the upcoming regulation of AI. And I think a risk-based approach is, of course, there's a huge parallel there. And the data privacy regulators recognize the benefits of AI, of course, but they also recognize the significant risks. And they do not take it's not a zero tolerance to risk. The emphasis is on identifying the risks at the earliest stage and taking appropriate measures to mitigate those risks. And what it does is takes a privacy by design and default approach. And so it's crucial to identify the risks at the outset, at the earliest stage in the AI life cycle, and then to identify appropriate measures that will mitigate those risks, with the focus, of course, on high risks. And the way that we approach that from a data privacy practitioner point of view is, as Raphaël identified, with data protection impact assessments, similar to conformity assessments for AI. And so the focus of the DPIA will be to demonstrate that the processing of the data is necessary and proportionate to the stated aims. Again, focusing on the high risks, identifying the risks and making sure that they are proportionate to the aims that you want to achieve. And so that's a vital tool, really, to demonstrate, document, assess, and identify all of those risks at the outset. Now, that obviously exercise involves weighing up the benefits, which have to be very clearly stated, against the risks to the individuals, and assessing the impact on those individuals, and, as I say, ensuring that that's proportionate. And then you would factor into that all of the key principles. I think lots of them have been mentioned so far already tonight, of accountability. So ensuring that organizations are responsible for identifying and mitigating risks. And I think it's a case of dedicating enough resource to that internally, and that resource should be proportionate to your use of AI and the risks involved and the potential impacts involved in the use of AI. Upskilling senior management so that they properly understand the risks. Obviously, some of these systems can be extremely complex and difficult to understand, but ultimately it is the senior management of the organization, as in data privacy, that has to be responsible. And if they don't understand the impacts and the risks, then they're unable to actually achieve that role. And of course, the other principles are of transparency. People need to properly understand what is happening to their data. This can be quite challenging, obviously, with complex AI systems. Fairness, so identifying and dealing with statistical inaccuracies and mitigating against discrimination. Again, it's not a zero tolerance, but it is a case of identifying the risks, identifying the impact, and putting in place appropriate checks and balances to deal with that. Another aspect is data minimization. So obviously AI traditionally requires large data sets to be used, and that's challenging in terms of the privacy regulation, which requires you to minimize the scope of the data collected, the access to it, the use of it, the retention to what's absolutely necessary for the stated objectives. But that doesn't necessarily need to be a conflict. It just needs to be assessed and factored in at the earliest stage possible when building these AI systems, going through the training stage. And of course, data security is a really key element to data privacy, and I'm sure will be in AI regulation, because again, large data sets, complex arrangements sometimes between different suppliers, different parties, and so it's very important to identify the specific risks as well that can arise in AI systems around the ability sometimes for those bad actors who can maybe determine additional data about the individuals whose data was used to train the AI system by entering certain factors, looking at the results, and being able to then determine from those additional pieces of personal data about these individuals. In terms of automated processing, that's obviously a really complicated factor in privacy regulation, and it focuses on automated decision making in particular. So the way that it's regulated is to focus on the solely automated decision making. And I'm not sure, are we ready to discuss this, or is this something that you want to discuss in the next question?
We will probably cover it, but you can talk a little bit about it now.
Okay, so I'll just briefly explain then. So data privacy has a real automated decision making is very much restricted under data protection laws, but it's particular types of decisions. So it focuses on those that have legal or similarly significant effects. So it focuses on really sort of high risk elements of automated decisions that can really affect individuals' lives, and then it restricts those to certain circumstances, and even further restricts them where what we call special categories, so sensitive, high-risk data is going to be involved. It's very much limited to explicit consent. And I won't talk further about that if we've got more questions. So that's it for me for now.
Thank you very much. I think that's we will definitely come back to that. I want to move into a discussion for about the next 20 minutes. I'll also be trying to moderate the chat to see if there are questions from the audience. But so, we have these themes here on the panel of trust and risk. So I thought maybe we could unpack them a little bit, starting maybe first with, and so I was wondering, maybe Barbara, you could start, or others could jump in, but just going back to this concept of trustworthy by design. I mean, we have security by design, we have privacy by design. How would this, how do you view this as a different approach to designing technology to be trustworthy?
Sure, I can start with that one. I don't know that I would say it's necessarily a different approach than privacy by design in terms of having a framework and building out controls and concepts in a company. But there's different elements to it than you would have for privacy by design. So at Workday, when we look at trustworthy by design, we really started with building out our ethical AI principles. So ours are, we put people first, we care about our society, we act fairly and respect the law, we're transparent and accountable, we protect data, and we deliver enterprise-ready AI ML technologies. And when I look at that in the concept of a broader trustworthy by design program, it's something that you have to make sure that you don't just put in place at one time. You define your principles, and then that's what it is forevermore. you have to build an internal process and look at governance process and come back and revisit those principles and make sure that they're staying up to date with what changes in regulation may be happening, what standards are happening, where products are going, and just have this continuous life cycle where you're able to come back and revisit and determine, are those still the principles that should be in place today? You know, should they be evolving? Should they be changing? And that's the concepts are the white paper published on to really looking at having this life cycle and making sure that there's the transparency, the governance, the accountability that I had spoken about earlier. But there are a lot of parallels to how you would build and implement a privacy by design program as you would with a trustworthy by design program in practice.
See if anyone else wants to come in on trustworthy by design. Particularly those from the privacy sphere. Go ahead. Yes.
Yeah, maybe just a quick remark on that, because I'm having in mind here. So I think that the principle of trust, for instance, indeed accountability, organizational measures. This is not where I would see the difference. Where I would see the difference in the regulatory design is I'm coming back to the points about the trust between regulators and regulatees. And for instance, I think that there is some experience that can be drawn from the comparison of the GDPR with other legal frameworks. Because, for instance, if you look at the way that regulators in the GDPR have supervision powers with the regulatees, and the depth of the collaboration between regulators and regulatees, this is very advanced in the GDPR, I would say, as opposed to other privacy frameworks. So for me, it's also not so much a matter of, what are the principles, because I think there is broad agreement on the type of organizational measures that should be taken to foster trust, but also how they're, implemented in practice, and how much actual trust are we going to give to the regulatees, and how active the regulators are going to be.
We lost your audio.
Hello, I was done from my remarks. I don't know if any of what I said was gathered.
Yes. Sorry, I seem to have lost audio. Can you hear me? Can you hear me? Okay, great. Sorry, I went away for a minute. Thanks, Raphaël. Just following up the trust aspect and kind of going back to Daniel's discussion of both the AI white paper. Yes, the delay is quite. You can hear? Perhaps we could get some technical support. Yes, you hear. I tried to ask them. Just going back to the trust notion, I'm wondering how you think the EU approach to the AI legislation compares to policies and principles that are being discussed in other countries. Daniel, I'm sure you have a view on that, but others as well. So maybe, Daniel, you could kick that off. And I'm sure you've looked at other approaches as you've worked on crafting your legislation.
Yes, so indeed, and to link it to your previous intervention, a lot of the regulatory framework, I think, is aimed at situations of uncertainty and lack of trust that arise when you have opaque AI automation used, so the black box problem. And yeah, this brings, of course, questions how to ensure that its use is legal, or when the safety is at stake, how can we be sure that it's reliable enough? And what we are trying to do with the legislation is to allow to check it, so the trust and check principle. And I believe the EU has a pioneering role in that it works on binding rules for this. On development and use of AI systems that present high risk to fundamental rights or safety. There are many strategies around the world, some guidelines and ethical principles, but not legal rules specific to the use of AI. So there are also initiatives, of course, on bans of facial recognition in the US, but this is a particular issue. So we hope to influence the international landscape. We had quite successfully done that, I think, with the GDPR. For this to happen, we obviously need to work closely with international organizations, but also like-minded countries, including the US. And I can recall that before Christmas, we proposed a new EU-US agenda. And there's a specific point on AI where we will propose to start working on a transatlantic AI agreement to set global standards, because rules established in a vacuum are bound to fail. So that is why we're involved also in the OECD One initiative that was mentioned in the beginning. We're also involved in global partnership on AI. That's a new endeavor. So this is really an important angle that you brought up.
Thanks. I thought maybe Francesca might want to come in there as well.
I think because I focus, my practice is privacy regulation. I don't have any knowledge about other regulations of AI in other countries, only from a privacy perspective, from a GDPR and a UK perspective.
I'm happy to jump in on this one. And, I think it does have so many parallels to GDPR and to privacy in terms of, as we saw with GDPR, really the EU is setting some of the global rules of the road. But, it is really important to us that as it goes forward and as the framework moves forward, that there is this eye towards global interoperability, because these provision of the AI and ML services are going to be truly global in nature. And so we don't want to have regulatory fragmentation that would, unnecessarily complicate the market, innovation. Instead, having a coordinated effort will really strengthen the capacity for these policies to safeguard trust. And in order to be able to demonstrate compliance, having standards is going to be a really, really key role in terms of being able to guide the regulation, being able to have accompanying standards where we can actually measure and demonstrate compliance. Because again, at the end of the day, to have these be successful, to have these be used, there's trust. And for people to trust them, they need to have these supporting standards to really be able to understand how to implement them in accordance with regulations, and to be able to demonstrate compliance.
Okay, I'm just moving on a little bit to talk about the second element that we've covered quite a bit, and that is risk. And I think Francesca talked a good amount about different kinds of data and looking at the risk they pose to individuals from a privacy context. Wonder if we could talk a little bit about how we should start to think about risk of AI systems. And I think one of the challenges is that with AI, it's hard to even know, as I said at the beginning, sometimes what we're talking about. And so should we look at the algorithm? Should we look at the data going in? Should we look at the decision being made or the information being given on the other side of the machine? And how we put that into a risk framework. So, for example, at the OECD, our One AI, our network of experts, is working on a basic sort of user-friendly classification of systems so that we can get to a more granular sense of what we're talking about when we talk about machine learning and more broadly AI. But I wonder how you feel where we are as sort of a global community in understanding those nuances and getting to an operational ability to assess risk and what you think we need to do beyond what we're doing now. So maybe I go first to Daniel. So I'm sure you thought about this, and then sorry to make you go first again.
No problem. At least I'll have free time at the end. So how to operationalize from our side? There are three things. One, by high risk, we mean two things. One is safety, health, and life. The second is fundamental rights, as I mentioned, discrimination, typically privacy. So first, the legislation would establish how we identify high risk, which arises not only from the technology, but also from the context of its use. And Barbara's reference to the life cycle is quite a nice analogy, I feel, for this. Second, we define what are the requirements when it is high risk. So for all other AI systems, there would be a voluntary, very light touch approach considered. We, as I said, legislation should only intervene when it's needed and in a proportionate way. And here it's getting a bit more complex, because for products it's easier because we can use existing mechanisms. We have safety regulation with conformity assessments attached already. So in this case, we would just say that if there's an AI component, we are just adding new potential requirements in terms of certification, whatever. With self-standing systems like public services, it's more complex, and this is really in the fundamental rights domain. Will I get a social benefit, etc. So if I want to use AI for recruitment, for example, I also have to meet requirements on data quality, documentation, the human in the loop, the things I mentioned. And now comes the third part. How do we ensure compliance with these requirements? And the difficult question is this ex ante, ex post mechanism. Self-assessment ex ante is a possibility, but maybe AI systems with increased safety implications may require a third party to do that. Ex post, of course, is the market surveillance, and that in any case, I mean, market surveillance will always be needed and able to check. But the goal of the legal framework we're creating is not to regulate the technology as such. The goal is rather to introduce rules for placing on the market or putting into use of a limited number of AI systems that can be considered high risk in light of their impact on safety or fundamental rights. So this is how we want to operationalize it. There are various ways how to define the use cases that will sort of trigger the system. I probably can't be too much more specific on this at this point, but certainly we have in mind that AI is a rapidly developing technology.
Thanks, Daniel. On risk assessment, does anybody, other panelists, want to weigh in here? Go ahead. Raphaël.
Thank you, Audrey. Yes, and actually, just a few remarks, and maybe I will also make the link with another element of the discussion. So as such, I don't have any, let's say, recommendations on what the criteria for assessing the risk would be. but I just wanted to point the attention to the fact that in the GDPR, the criteria that we use are very much connected to the FIPS. So, for instance, we talk about the amounts of the number of data subjects, type of data, and so on. So you can really make the link with principles such as purpose limitation, data minimization, and so on. And so again, this just makes me think that, well, we don't have, as far as I know, FIPS, these sort of substantive principles for AI, which could function as an anchor point for conducting our risk assessment. So maybe we will talk a bit about this later, but yeah, that would be my 2 cents on this one.
It's interesting. Would others agree that there's not an anchor point for assessing AI like we have the FIPS for privacy? Curious in reactions, given how many ethical frameworks have been put out. And the OECD principles and whatnot. I think we're still very early in the AI assessment phase, and so the FIPS are a well-oiled machine in some ways at this point and are foundational to all privacy law. And should that be our goal for AI, to have something like the FIPS? It's a good question.
Yeah, I would agree. We don't have something like that yet. And one of the challenges is in assessing AI ML risk is it really ends up being a very currently fact intensive exercise that you're having to look at. For example, not just what sector's deploying it. Is it a deploying or a use of AI? But what is the specific use case? Because if you just look at a specific sector, there may be a lot of low risk uses of AI that you shouldn't have to be spending quite as much time going through all of these assessments. And if you go into a low risk sector, there may be a couple actual high risk situations in there. And so I think you have to pull both together and focus on the sector as well as the specific use case, and then be able to do this probability of what the severity of the harm is. And there isn't an easy checklist today to just do that. I think it's one of the problems we're all trying to solve, to make sure how we can do that in a way that still allows companies to innovate and to deploy this type of technology in an efficient way.
Thanks, Barbara. Along those lines, I'm just going to pull an audience question. How can we achieve harmonization on the ethical legal framework governing AI, especially regarding AI applications addressed to global audiences? So sort of along the same theme, the 1980 OECD privacy principles, which are sort of the foundation of the FIPS, are very broad and have been considered and thought about a lot over time. Do we start broad with AI? I mean, or do we start detailed? I guess would be one. I'm wondering if Francesca, you have a view, having been through it on the privacy side in a very practical way, how to sort of get to a more harmonized system and how to get a sort of foundation that we can all work from.
Yeah, I think it's very difficult to strike the right balance between having a too prescriptive approach and having an approach that will fit all of the different circumstances. As Daniel was saying, you have, or Barbara, sorry, I think it was you have very high risk applications, and then you'll have lower risk applications. And the way that the privacy regime has developed is in a way that I think the stricter, obviously the stricter principles, the stricter obligations are for the higher risk. And so it has to be the right mix, really, between very prescriptive and very high level in order to deal with all of the different applications and all of the different types, especially as technology evolves, in order to harmonize it across the board.
Great, thanks. Anyone else on the harmonization of ethical principles and want to come in on that? The question from the audience on the panel. Let me go to another audience question. There are a number of proposals for AI audits, do you think such audits are the best way forward, especially if such audits are not carried out by government agencies, mostly due to lack of resources, but instead by private entities?
I can jump in on that one again. I mean, I think I touched on that earlier. Just, I know we're short on time to keep it brief, but I think to the extent we can agree on standards and well-respected standards bodies, and then a company can get assessed against those, I do think that is a great way to demonstrate compliance and build trust, just like we do in security and privacy today.
Is there a role for government in your mind in assessment? Go ahead, Raphaël.
Yeah, very quickly, I was also going to point to a remark that I made earlier, and I mean, I don't want to sound too much like a GDPR ecstatic person, but I think I very much like the regulation approach and the governance approach that's been taken in the GDPR, where you leave some leeway for private actors, including for codes of conduct and certification practices. But you still make sure that you have a solid interaction with regulator who hopefully can have sufficient oversight. So I think this is the type of goal that we should be looking to.
That makes a lot of sense. Another question from the audience. Do you think that advanced AI might replace conference panelists and/or audiences in the near future? What should legislation look like to address such risks? I think they're bored of us at this point. No. What do you think? We're going to get replaced by robots?
I mean, maybe it goes to the, we don't think it looks at replacing humans. You know, at Workday, we think one of the great advantages of ML is really being able to augment decision making. Maybe it'll help recommend who should be on the panel, but we don't see it as replacing humans, but rather helping inform maybe which topics we should be focusing on as we go through the discussion here.
Very well put. Anyone want to take a counter view of that?
Yeah. No, I think in my own interest of staying on the panel, I just like to say that there's the principle of human agency in the white paper already, and a more general philosophy that we are sort of mainstreaming into all the proposals in the digital area, and that's the fact that technology should serve the people, and I would fully agree with what was just said. I mean, it's to augment what humans do, and it shouldn't be the way that we have to, you know, adjust to technology or
I think we lost Daniel again there quickly. So Raphaël, I have a question from the audience from you and to everyone, but specifically Raphaël. Too often risk is identified with objective or science-based regulation, whilst the very political nature of the choice of regulating through risks is overlooked, if not neglected. In other words, regulating by risk may favor, by its very nature, the tendency to hide political decisions. What do you think about that?
Yes, I agree 100%, and I think that really touches upon the remark that I made in my slide, so about the situation of nanotechnologies, where clearly the European regulators hid behind the scientific uncertainty in order not to regulate. So I fully agree with that, and I think that this is indeed something that is very much put forth, I think, in a lot of debate, and I mean, maybe just to clarify, I'm not a sort of risk-based approach enthusiast. I'm not here to say that it's better or worse. It's just I just happen to have some expertise on that. And with that being said, I think that one of the things that I always try to emphasize that the risk management process is loaded with a number of subjective elements, and in particular, the decision whether to take a risk or not is always very subjective. So I can only agree with this comment.
Very good. Anyone else want to agree or disagree on the panel? Everyone's in agreement. That's good. Okay. We're getting to the end of our time. I'm just gonna wrap up with a couple more questions. So there's a lot of privacy expertise around the virtual table, specifically Raphaël and Francesca. You both talked about what we could learn from experiences around data protection frameworks and legislation. To what extent do you think the concepts of automated processing and the right to object to decisions on the ground are a useful basis for new AI regulation?
Yeah,
Either one of you can go first. Oh, go ahead, Francesca.
I'm happy to start. Yeah, as I said in my previous my previous remarks, so automated decision making is specifically regulated under the GDPR, and the way that it's regulated is that it focuses on particular solely automated decisions that have particular impact to individuals. So things that have legal or similarly significant effects. So things like credit rating, if you refuse credit or you're refused a job. So anything that has real significance to the individual. And there are specific circumstances in which that's permitted under GDPR regulation. And those circumstances are there or designed to benefit the individual. So where an individual wants to enter into a contract, for example, and that's going to be based on AI in making the decision regarding that, but that's something they've decided they want to do, or if they explicitly consent to it. So the system is set up to benefit the individuals, to enable these kind of solely automated decisions with no human intervention. Obviously, there's a much higher risk in those circumstances, but they're permitted where they benefit the individual. But even when the automated decision is actually permitted, there are very clear safeguards that need to be in place that I think will need to be replicated in the regulation of AI. So human intervention, going back to the question about could we be replicated by AI, the GDPR is very keen on human intervention, on human interaction, and so even if solely automated decision making is permitted, one of the key safeguards is the right to have human intervention into the decision. So for the decision to be reviewed by a human and for the individual to express their own point of view, to guard against inaccuracies in the system, to guard against bias, discrimination, the way, depending on how the machine learning process has been developed, and issues in the deployment of the AI. So there are these very key safeguards. And another key aspect of it that I think is applicable to the AI regulation is, of course, transparency, which we've talked about a lot tonight. But there are specific obligations to give meaningful information to the individual. So to tell them, first of all, that this is an automated decision, to give them really meaningful information about the logic that's used to make that decision and the consequences to them. And that's obviously quite challenging for certain complex AI systems. Just in effect, having to give a meaningful, clear explanation to an individual, depending on how complex the system is and what's involved. Sometimes, even those that have to make those explanations don't properly understand the ins and outs of the system, the complexities sufficiently to do that. And of course, if you can't properly explain to the individual how the system is working, then you can't enable that individual to exercise their rights. So they're not able to exercise their rights in relation to how their data has been used if they don't understand how their data has been used. So it can be very complex. Also, the other aspect is human intervention in itself, enabling a human to be able to intervene in an automated AI decision in itself could be very difficult because you need to the systems need to be designed from the outset to enable the information to be given to the individual and also to enable human intervention. So there needs to be an ability to have a meaningful review of that decision and of the impact on the individual. People need to be trained, the system needs to be designed to enable that to happen. And there are significant benefits, of course, not just in terms of complying with regulations and being able to assist individual rights, but in terms of increasing the performance of the system, because unless errors can be identified and corrected, then the system is not going to perform correctly in the first place.
We're down to the last few minutes, but Raphaël, I don't know if you want to also respond to that one.
Sure, I'll try to go very briefly then. So I think, of course, so this provision has a lot of potential, but to me, what's missing is that it really focuses on the decision-making aspect. And at least that's my opinion in the GDPR, the knowledge inference process that underpins AI is completely left unregulated. So of course, that brings me back to the point of the AI FIPS. So in this regard, I took good notice indeed that the AI white papers, and also Daniel, you mentioned, so that there would be such kind of principles, but that they would only be used in case of high risk applications. But at least in terms of safeguards, I would really find it strange if there was nowhere in a regulation something that allows to touch upon the whole knowledge inference process. So very quickly.
Okay. I'm going to give Daniel and Barbara just one minute or two to react and respond, and then I'll just do a quick wrap up. Barbara, you want to go first?
Can you hear me now? Sorry. Is that better? Okay. I'll be very quick then. Data protection laws dealing with automated processing are absolutely a part of this larger AI ML discussion. But data protection is really a subset of AI regulation. As we look at it, data protection is focused on use of data, where AI policy is going to have to address much, much broader issues in terms of than just what data was used and how. So I think this is absolutely part of the discussion. We absolutely have to talk about automated processing in context of data protection laws, as well as with AI ML. But we need to also just look at much broader topics as we look at it, and in terms of governance strategy beyond just automated data processing or automated decision making.
Daniel, you're back just in time to take the last word.
Yeah, well, not much to add. I fully agree. Just maybe since we're on this topic, I can wish you a happy European Data Protection Day, which is today. Align.
I think we had Daniel fade out again. Well, hell, I know you guys that we're standing between you and I think some social gatherings at CPDP this year. So I just want to wrap up and say thanks to the panelists and to the organizers. I think we covered a lot of ground, particularly on trying to unpack a bit risk and trust, but also this concept of needing a FIPS for AI, which I think is a kind of the tagline of the panel for the day. And Daniel's back. Daniel, I don't know if I give you one minute left to say you were about to wish something and then we lost you.
So you lost me at the very beginning. I wanted to wish you a happy European Data Protection Day, which is today. Since we're on this topic, and there's not much to add to what Francesca, Raphaël, and Barbara said. I mean, today users of AI are subject to obligations from GDPR when they use and process personal data. We need to be able to ensure that it can still be used where a system is opaque, but indeed it's a much broader set of questions that we address today, so it's only part of it. But I can also all the time when you have AI systems that can lead to discrimination, fundamental rights. So there is a very core connection of GDPR and the legislation. Thank you very much.
Okay, good. Well, thank you all so much, and happy Data Protection Day around the world, wherever you are joining us virtually. Have a great day, evening, and we look forward to seeing you next time. You can wave goodbye.
Happy Data Protection Day.
Bye.
Bye-bye.